Good morning, everybody. It's a few minutes after 8 o'clock, so we'll get started and get you out of here by 9. Appreciate you all being here. We've got a little bit of a lighter turnout, but I think it's back to school time, and everybody's got a lot of new things going on. We actually have 3 board members, including, or 3 folks from the board, including our administrator, Katie Centel, up in Chicago this week for officer training and kind of chapter education. So excited about that. It's a program I participated in last year, and I think it's a really good offering. So a little bit lighter crowd, but it's going to be a great program nonetheless. So appreciate y'all being here. A few chapter announcements. I'd like to thank Liza Harrell for stepping in Katie's shoes and helping us run the meeting this morning. Couldn't do it without you, so thanks a lot. Appreciate that. Little update on the schedule. We have our next meeting will be on September 26th. It'll be here. It's going to be called the Tech Update, and we'll get discussion with Michael Bull, CCIM, who y'all may know, and Les Atkins, who's kind of a social media and marketing consultant. Neat guy. I've heard both of them speak. It's fantastic. So definitely want to be here. It'll be not just social media, but marketing and all kinds of exciting ways to promote your business. If any of y'all know Michael, he's pretty good at that. So good to get his insight. We are offering a CI 103 class. That will be the week of September 23rd. Right now, the class capacity is about 40 students, and we still have some seats. So if you're working on your designation and need to get that done, we'd love to have you do it here in Atlanta. Otherwise, please promote it in your offices. We do have some scholarships that are available. It's a partial scholarship, but it's definitely helpful. So feel free to contact me or any of the board members, and we can get you the information and the application on that. Going into October, on the 22nd, we've got a networking event planned. All the details will be sent out to you, but it's going to be at a First Citizens Bank location. Should be a good time. Be totally a social event. And then, as I mentioned, in October, we'll have our October meeting, the 24th, which is going to be called Deal Valuation, Art or Math. It should be a great panel and a good discussion. So that's the current events. Also, put on your calendar a little further out, November 13th will be our economic forecast, which is always a sold-out event every year, and we're excited to have Dr. Shannon again speaking. Lastly, but not least, I would like to thank our sponsors, Marcus & Millichap, Ackerman & Company, Adams Realtors, The Simpson Company, Wells Fargo, Standard Landscape, Brand Properties, Bank of North Georgia, Excelligent, Anderson, Tate & Carr, First Colony Financial Corp., and Strategic Exchange Advisors. Please keep these folks in mind in your daily practice. We appreciate their support and are able to offer programs like this because of them, so thank you very much. So that concludes the announcements. I'm going to transition, and I'm going to introduce our moderator, Mr. Carter Stout. So come on up here, Carter. I'll keep it brief. Many of y'all know Carter. This is, I think, his 3rd or 4th year moderating this panel on the legal update, and so he certainly knows the organization and is an expert in real estate. Over a 28-year career as an attorney, focusing on transactional work, both leasing, acquisition, and then all the related services that are required. His firm, is about 5-6 years or so, is called Stout, Kaiser, and Hendrick, LLC, and he's a native Atlantan and has been on lots of boards. I'm not going to read them all to you, but it's an impressive list. But I would say most recently he's been the treasurer of the real estate section of the Atlanta Bar Association, and he's been on the board there for 3 years. So clearly very qualified and capable attorney, and we're glad to have you moderate. Great. So thanks for joining us.
As most of you know, the August program for this group has typically been the legal update. As Jeff said, this is probably my 3rd year for doing this panel. We've got 3 attorneys with us today that are well qualified to speak on the real estate market from a legal perspective. This morning we're going to focus on sort of 3 main areas, one being market perspective. Over the past year, what's the change in the volume of your work, clients, how your clients have changed, and the type of work versus a year ago. Then we're going to spend a little bit of time talking about legal developments. I typically have always sort of looked through the cases for the year just to see if there's anything of interest or of note that I think you would be interested in, and nothing popped out at me. So particularly with Alon and Phil's background, we're going to spend a little time talking about loss share arrangements, some of which are coming to an end at the of their 5-year term. And then finally, we're going to have spend a little bit of time just talking about the attorney-broker relationship or the role of the broker in a commercial real estate transaction. We want to make this an informal, so feel free to ask questions. We will certainly leave time for questions at the end, and I've asked the panelists to feel free to ask one another questions. The three panelists for this morning, the far side is Dan Bradfield. Dan's an attorney with Arnold Golden Gregory. I believe this is his third time on the panel. As you may recall, Dan was in the Navy and specialized in undersea mine warfare. Phil Mays, this end down here, recently joined Glass Ratner. I've known Phil for many years, since his days as an associate at my former firm. And then in the middle there, Alon Price, I don't think needs any introduction. I want to thank him for introducing me to this group. So I'm going to ask each panelist just to go down the line here and give a little bit of their background and to give you a better understanding of their perspective this morning. Phil, do you want to start?
Sure. Phil Mays. Currently, I'm the Chief Legal Officer at Glass Ratner Capital and Advisory Services. A lot of you may know Glass Ratner. We have a large distressed book between receivership and management that we handle, about $1 billion worth of product across the U.S. Prior to that, which is just as of May 15th of this year, for the past 3 years, I was the Portfolio Director and Chief Legal Officer of Everbank Commercial Advisors, which is the, in banking terms, the commercial bad bank at Everbank out of Florida. Actually, I just relocated from Jacksonville up to here not very long ago, although I was here for a good 14 years after law school, which is how I'd met Carter in the early days of the early 90s, back actually in the RTC days, ironically. But at Everbank for the last few years, I ran the platform that handled the distressed acquisitions the bank was making. Everbank had some wins on the FDIC side of multi-billion-dollar failed institutions, and of which over $1 billion was commercial distress. So I'm coming from running that platform for the past 3 years as their portfolio director and legal affairs manager as well. So, and before that, I was practicing law at a firm and as well as in-house.
Thanks, Phil. Alon?
Hey, I'm Alon Price. Most of you guys know me. I am an attorney and am a real estate broker, CCIM. I worked as a commercial real estate attorney for 7 years. Then I went into the investment and brokerage side. When I looked at those closing statements and saw all the commissions that the brokers were making, I decided maybe I should switch careers, which really wasn't a bad thing, was a very good thing. In 2010, I went to go work for the FDIC as a loss share auditor, and I did that for 2 years. And then in 2011 decided to switch sides, and now I represent borrowers against the FDIC and loss share banks. I have a law firm and a brokerage firm, and I'm pleased to be on the panel. Thanks.
Good morning. My name is Dan Bradfield. I'm an attorney with Arnold Golden Gregory. I've been over there 9 years now. My practice focuses on acquisition and development across all property types, whether it be industrial, multifamily, retail, office. I particularly like multifamily, if you were to ask which one I really like. And prior to being a lawyer, as Carter alluded to, I was in the Navy, and after I wised up, I went into manufacturing, and after I wised up, I went into banking, and after while I was in banking, I decided, hey, let me go to law school. So I went to law school at Georgia State. And probably 75% of my practice is acquisition and development, and probably 25% is leasing. I also do and really enjoyed doing construction documents, AIA construction negotiations. I find that a lot of people sign what's put in front of them, so I like to help them out in that regard. My connection with brokers. Had the privilege for 5 years serving on the Atlanta Commercial Board of Realtors Forms Committee, which I really got was just educational for me, learning the broker's perspective on deals rather than just the attorney. So happy to be here. Thank you.
Dan, why don't we start with you on since you were on the panel the last couple of years, and talk about market changes that you've seen in the past year.
Sure. Well, there's certainly no tidal wave, right? There's no booming sort of storm of recovery. From this year to last year, I personally have not felt a large change. It has been progressively steady, maybe is the key term, not gangbusters. And that has been across, again, all property types. Probably early part of last year, if you were to point to a boom, it would have been in the multifamily. But even towards the end of last year, we were starting to hear word that, that's kind of played itself out. I am seeing, and talking to a prospective client yesterday, they were excited, or they're in the business of acquiring your triple net properties, single tenant buildings, and his perspective was that he is seeing that as overheated, which points to the fact that people are still looking for the sure thing. Let me get something that is operating, low risk, and acquiring that piece and being satisfied with that. Although he is at this point looking to re-enter the market, so that, in some conversation with other clients, it sounds like there's some optimism there. So just sort of an overall perspective, no gangbusters, no real hot thing. It's more blocking and tackling. It's more a steady sort of approach, but nothing that I personally have experienced any sort of super swing to say that it's going one way or the other.
Dan, what about lenders? Are there more lenders out there more willing to lend money? And also, want you any comments on appraisals and appraisals effect on closing these deals?
Yeah, with respect to lenders, we, as I was talking with Phil just before the panel started, our affordable housing practice at AGG is going really well, which points to that money is available, and it's a what's the right term? It's a more of a sure thing that is available. Appraisals are still key to the loan. The money is, while at low interest rates, there's a large equity requirement still being required, so. But one sort of interesting point in that, I think last year we were talking about conduit loans, and I think I even made the comment that I think I did the last one as of that morning, and I haven't done one since. So that's another sort of indicator of where you got to go get your money.
Thank you. Alon, what's your perspective on the market, and particularly what you're seeing in your law practice?
Well, I would just like to sort of ask Dan, between 2009, 2010, 2011, so over the last 4 years, there certainly hasn't been a boom, but we have seen sort of an uptick, right? Please say yes.
Certainly an uptick. So you go from 2008, I can tell you when it started. September 2008, you can see my billable hours. Boom, drop. 2009, it stayed and went further down. 2010, a little tick. 2011, a little bit more. 2012 and 2013 have been the same. So a slight uptick, but nothing like, parties on. No, nothing like that.
Okay. I just want to make sure that my heart's still beating. For me, most of what I do now, I do a lot of tenant rep, and I do a lot of borrower representation against the FDIC and loss share banks. And so I've seen quite a large uptick in the loss share banks. They have a 5-year agreement with the FDIC where after 5 years they no longer receive the reimbursements for recovery on assets. Now, that doesn't mean there's two things that are happening there. The one is, as that sunset date sort of comes, and they'll no longer be reimbursed for the recovery, we've seen them starting to fire on all cylinders, and so some of the loss share banks are better at doing the loss share, interpreting and performing their duties under the loss share agreement than others, right? I have some clients that have a portfolio of properties, say they have 4 properties, and the loans are all with one loss share bank, and on one loan they are foreclosing, on another loan they're suing on the note, and on a third loan they're suing on the guarantee. So they're looking at the loan, they're looking at the borrower's total global financial picture, and they're trying to see where they can maximize their recovery as quickly as possible. And so they're sort of choosing which gun to fire. And so I am seeing a lot of borrowers coming to me now where that sunset date is approaching, and suddenly the bank which has been extending their loans since 2008 is no longer has refused to extend the loan, and now are taking some sort of legal action. At the same time, although there is a sunset date on the reimbursement, there is a 3-year look back on the recovery. And so what that means is that it's an 8-year agreement. Although they won't be reimbursed after 5 years for the loss, the FDIC will still share in any recovery that they have. And they're still under a duty to maximize recovery. So what that means for us brokers and investors is, just as Dan says, there will be no sort of, airplane flying across the sky saying the party's on. Right, because they're still under a duty to maximize recovery, they can't just dump assets, right? And that's been sort of the problem for the last 4 or 5 years. Or I don't know, some might not consider it a problem, some might consider it the way that we've sort of got ourselves out of this mess, which is everything has been sort of in slow motion.
But after the 3-year period, I guess the total 8-year period, then you might see the dumping of the assets?
Well, I'm gonna let Phil respond to that, because he works for a bank. So, but yes, I mean, technically speaking, you should see some of those. Now, one of the things is, and Carter, just interrupt me whenever you're ready. One of the things is that after 3 years in the loss share agreement, the acquiring institutions were supposed to be able to sell notes in bulk auctions with the FDIC's consent. Well, guess what? The FDIC did not provide that consent. So we still have not seen sort of just a bloodbath, really, or just those assets being sort of, released all at once. What we're seeing is still that slow motion trickle, 2008, 2009, they just extend and pretend, extend and pretend. In essence, it's still extend and pretend, although the market has started to come back. I am seeing appraisals sort of in line with what land, especially land, because land was to take the first hit, right? Land took the first hit. One of the reasons why I believe that is because everyone wanted to avoid the intangible tax on a 3-year, 35-month note. So all of the land deals were 35 months. Well, when those were the first notes to come up. The rest of the deals were 3, 5, 8, 10 years, right? So I am seeing appraisals on land seem to come in line. And I can give you an example of that, and I can't name names, but I can tell you that a loan on 200 lots in Putnam County, not the sexiest in the world, right? But still, 200 lots in Putnam County. The loan was $1.8 million. They were offering the deal at $150,000 for the 200 lots. Okay, so that seems to me a little more in line with what those lots are really worth, because there's a 10-year, 120-month supply of lots in Putnam County. That's 10 years, right? So if you're willing to sit on your money for 5 or 10 years, then that's not such a bad deal. I don't know how many of us that work with investors who want to sit on their money for 5 or 10 years. But, so what we're seeing, at the same time that I'm seeing an uptick in my business because there's many borrowers that need help, and I know those are many of your clients that have got into trouble and need help in one way or another, and we've found successful ways to negotiate out of foreclosures, bankruptcies, etc. I don't think ultimately unless we're looking at Dan 3 years from now, when Dan and I hopefully on this panel again, we can say, well, 3 years ago we said this and this is what happened. Well, as those sunset dates come for each loss share acquiring institution, you know, I don't believe that we're going to see a huge uptick. I think we're just going to be sort of trudging along slowly, and it will keep getting better every year. And until we sort of see substantial job growth or something that sort of sparks the economy, I think we're just going to, you know, just keep holding on.
Phil, why don't we, instead of you talking about sort of market perspective, we'll come back to that, and maybe you could just address some loss share issues and where you think we are, or the impact of this. Some of these banks coming to their 5-year term, end of their term, headed into a 3-year tail provision. What you're seeing in that regard?
First, and I will speak a little bit to the first part. Scott, I can quickly say that over the last year, and you have to remember, I've been out of the bank for 3 months, but I was running that platform for 3 years, so I'm not there any longer. But I've spoken a lot nationally on loss share on the platform we were running, and with a lot of the other people who were in my position, my peer group at the time. We were hotly pursued by lawyers, brokers, the conferences, and everything, because it was such a new thing at the time a few years ago, the loss share. And there's still about $200 billion in CRE and loss share deals across the country. And I think you know, a lot of us thought that it should have been flushed out a lot quicker. It would have been better for really everybody, including I think the economy would have gotten things really moving again by pushing stuff out of the banks and getting them back into investors' hands who would actually do something with them, versus the banks who tend, we're not good property owners as a bank. That's not our core business. And even on teams like the one that we had at EverBank, which was a new team, we didn't work with bankers. When I was brought on there, the only reason I took that job was they said, here's $1 billion to distressed commercial real estate portfolio. You don't have to hire anybody from the failed banks that we just acquired it from, and you don't have to hire anybody from our bank, because the bankers were not good at this, and they were good lenders, not good workout folks. But over the last 12 months, when I was at EverBank, and we had a portfolio that very heavy Florida and southeastern U.S., we had stuff here a good bit as well. We saw on the distressed selling side really a huge uptick. I mean, the money was coming in, borrowers were coming back in, getting recapped. I mean, I was surprised how many borrowers could come back in and salvage their own deals. So we saw a real desire to move on that.
That's because they had good attorneys, Phil.
Yeah. Well, no, they had capital partners now in an improving environment.
And Phil, what kind of properties were these?
It was across the board, really. Now, none of that Class B rural land stuff that should have been a tree farm already. That stuff's not coming back, and probably not coming back anytime soon, except for the next bubble. I don't see that. But anything that was remotely income producing in a decent market, and forget if it was in a core market like Atlanta or I don't know, or God forbid, South Florida, which is on fire again, that stuff would move fast from the perspective of our book. And as we were looking, we look at different areas of the country where we have our distressed book, whether it was the South Florida market, Central, going up into Atlanta, into Charlotte. And what we were seeing from our selling standpoint in the Atlanta market is we actually liked, which was we were seeing stability. We weren't seeing the uptick we were seeing in some parts of Florida, but stability, and the investment community who are providing the capital, looking up and having, and I don't know what you all are seeing, I'd be interested to hear it, but from our standpoint, we were seeing a lot more activity in this MSA from the distressed book we were running, and it was pretty interesting. And we were seeing a lot more bridge lenders and lenders wanting to come in, not your traditional lenders, unless you had a lot of capital. But these guys like Sabal, these folks like Sabal and Colony, these folks are trying to figure out what's their next play. And what they're trying to do is lend to ADC, and because the banks aren't really in that space very well. So you're seeing these other types of lenders. I don't know if you're seeing those in your closing practice, but we're seeing those folks on the lending side on our former portfolio.
So just to educate the audience, Sabal is a private equity group out of California, and we've seen, Phil and I have seen a lot of activity from private equity groups, both large and small.
Yeah, Sabal has about $6 billion, and they're probably one of the most active purchasers still left at portfolio level in CRE. And I mean, they're the ones, and they do. I mean, they use the brokerage community very heavily, and they have an extensive book of commercial property, and they're a big acquirer.
So I think this year they acquired either from BB&T or Regions Bank.
Yeah, they're all over the board. But I mean, it's not like it was the old days. These folks, there's only 5 or 6. I mean, really, I think on the legal side too, you know, or the brokerage side, there's only 5 or 6 big players out there that have aggregated billions of dollars. Realty is the best known one for certain reasons, but for lesser known, for as big or bigger as Colony, Sabal, Lone Star, and they use certain servicing companies, but they certainly are all out there because they were similar to us at Everbank Commercial Advisors. They're all out there trying to move their product as it's coming in.
Thanks, Phil. Hey, do you want to, I don't know if you've got anything to add as far as what you've seen change in the market in the past year? Is there anything you want to add?
Well, I mean, I think the uptick, you know, that we've seen across the board, especially in core markets, has been very encouraging. So we've seen all real positive, and we see Atlanta as actually a real opportunity because whereas I'd say South Florida is really kind of stabilized and really moving up. I think from a macro perspective, we feel that Atlanta is stabilized and just looking up. So for the investors and developers and so on, there's still opportunity, you know, at well-placed land or well-placed assets to make a move. And I think you would see that from the investors and folks that you would represent. Their capital providers out of New York definitely feel that this is a good market and they want to be in it, and how can they get here?
Those folks that have, or companies that washed out with the recession and are no longer playing, they have washed out, and so now you've got folks who are stable, who are looking to take advantage of the pricing that's currently available. And it seems to me that we were kind of predicting that to occur maybe 2 years ago, and it took so long to get to here. But now we're in that sort of environment where we say, yeah, now things might move.
Right, it's the job growth there and so on that we're, you know, and we were thinking this is a pretty good market. I mean, from the activity we were seeing in my former book, I mean, this is a very active market on the distress side because people feel that there's still that opportunity.
And Alon, the other day you were in my office and we were talking about foreclosures that you've been tracking. Do you want to talk about that? Because I think that's sort of fits in nicely with the whole idea of trying to take advantage of opportunities.
Yeah, and so this is my own empirical evidence, which none of you are to rely on in any way whatsoever. Alon did not say this, even though it's on camera. But you know, so I've been tracking the sort of commercial foreclosures. I look at them every month. I look at Fulton County, Cobb County, DeKalb County, and then I sort of filter through them to see what's actually, you know, sort of worthwhile. That's not just land. That's something that's income producing. And over the last 2 months, I've seen basically the commercial foreclosures that are advertised doubled. And so seems to me a lot more out there than there was, you know, compared to the beginning of the year. Now, I'm not, you know, I don't have sort of any empirical evidence as to why, except my own opinion and the opinion of those here on the panel. You know, I think it has something to do with the fact that there is a sunset date on the loss share agreements. But if you sort of break down the foreclosures by who is foreclosing, right? And so, just to give you an example of those. We're not talking about a lot of numbers here, okay? On the 3 counties, every month prior to the last 2 months, I could probably identify about 10 properties that were worthwhile. That's 10 properties over 3 counties, okay?
That's 10 out of how many?
Out of how many foreclosures in general?
Commercial
foreclosures.
Commercial foreclosures? Probably about 10 out of probably about 25. Okay. Now what I'm seeing is we're at about the number 25, not 10. Okay. If you sort of break down those numbers across, you know, who are the banks or who are the institutions that are foreclosing behind those, you've got 60% of them are the private equity guys, the Rialtos, the Sabals, right?
Go ahead. Right. So what's happened there, and that's not a sign of distress. you know,
That's
in
a
this
good sign.
market, it's a good sign.
It's a good sign.
It means that you get it out of the banks or worse, a failing bank that just can't make a move on it. And the private equity guys, they're not regulated like we were at a bank. Those guys will move really fast. They want to maximize recovery. Most of them don't feel that they're a developer, so they want to move. They're going to move that product out, which should be a benefit to all of us, really.
Right.
Versus holding it like the banks. A failing bank has a lot of problems selling properties because they can't take a further mark on their book. And in a healthy bank like we were, we still have a problem because we're battling the FDIC to sell.
Right. Yeah. Yeah. These guys don't have those kind of restraints, and so this is good news. The fact that the commercial, I don't know, maybe I don't seem very awake this morning, but the fact that the commercial, we're seeing an uptick like that is great news for us. I mean, we're saying basically what I'm saying is just from what I've looked at over the last 3 months is that it's doubled. Right, even though it's still not a huge amount of volume. What's interesting about some of the transactions, one transaction that I followed was a hotel transaction where there's a Marriott Residence Inn on West Peachtree, on Spring Street. I don't know if you all know where that is. It used to be an old apartment building. It has these wonderful porches. They converted it to a hotel, right? What was interesting about that particular deal is that it's about a $20 million property, and the folks that were foreclosing on it were hotel operators who had purchased the note, right? And I don't know at what kind of, the amount that was owed on the property was $10 million. So the $20 million property, the amount that was owed was $10 million. So that's going to pique my interest, right? As a CCIM, you can do the math very quickly there and figure out, well, wait a minute, this property is worth $20 million. There's only a $10 million note. There may be a deal here, right? So, and that's really how I've been looking at these, is to see if there's a sort of an arbitrage between, what the value is and what. And what the loan amount is. And certainly not just looking, the valuation is sort of my own artistic, looking at tax value, looking at the purchase price, and then sort of multiplying by 0.75 or some sort of number less than 0 in order to get to what I think is the value. What was interesting about this is that the people that purchased, that were foreclosing were hotel operators who purchased the note and then foreclosed since the note was in default. And then they purchased it at I spoke with the attorney who did the foreclosure, and they purchased the property for $4 million at the courthouse steps. Now that's a good deal, I don't know. Okay, but what's interesting about that is that these folks who are experienced hotel operators are out there, and their acquisition strategy or tactic is to buy notes from hotels, right, and then foreclose on them for a discount. They bought the note at a discount, they're foreclosing at a discount. So I think what's sort of a red flag to all of us is, okay, this is sort of a different way of approaching how a hotel operator or how any sort of business is now looking at their real estate, looking at their portfolio of real estate and how they can best acquire in this market. Now, a hotel is a lot of management, right? So you really, you're sort of at the upper end of, you see the hotels that go into receiverships. I mean, you've basically got, if you've got 100 rooms, that's 36,500 spots you have to fill every year. It's at the upper echelon of management. You really have, it's like ice climbing. You really have to know what you're doing, right? But these folks obviously have found a very, very good way of picking up properties. And so I would just, not caution, but it's a sort of an indication to our audience as brokers that there's new ways of doing things, and this is something one should look at.
Great, thank you. Let's sort of shift to the role of the broker in a commercial real estate transaction. I know most of my practice is transactional oriented, and that a broker can really help make the process go smoother. I think Dan is our transactional attorney on the panel, so I'll ask him to give us his thoughts on how to improve that relationship and the role of the broker in a transaction.
So last month, I was giving a presentation at the Atlanta Commercial Board of Realtors on purchase and sale agreement. And I was talking about the standard form, and the standard form provides for the broker to sign the contract along with the parties. And I announced in front of all these brokers that I prefer not to do it that way as an attorney. So after I ducked and got up from behind the podium, I realized that maybe I shouldn't have said that in that audience. In terms of the general subject, there's a role for the broker to play, and when the broker, from my perspective as the attorney, when the deal comes to me, I'm looking at, often I'm thinking, okay, the broker has done their job. They've worked this. And now it's time for me to take charge of the transaction. I'm a lawyer, that's kind of what we do, and so we take the bull by the horns. But I, as the attorney, can sense when I've got a good broker that I'm working with or maybe not so good. The not so good is quite obvious, is the broker disappears and shows up at the closing table, right? And there's been all this sort of activity where we could have used some help or some perspective or what have you in between. The other side is where I'm trying to negotiate documents and what have you, and maybe the broker is eager to get the deal done, obviously, and as we all are, but is injecting themselves into sort of legal issues and what have you that becomes a hindrance to the deal. Somewhere in between all of that is the middle, and when you have, I've worked with great brokers where they're collaborative, they're asking questions, they are just everything from getting a perspective of who this buyer or seller is, depending on who I'm representing, who they are, what the opposite side's perspective has been, and especially if there's an obscure issue or what have you that we need to deal with. From that sort of high-level approach to maybe there's something that we need from the city, some sort of letter that says, you can grow grass on the property. I don't know, some sort of obscure type thing that would cost the client a lot of money if the attorney were to spin their wheels on City Hall, whereas the broker might already have a relationship and can, hey, wait, I know Bob down there. Let me go sit in his office and try to get this letter or what have you. Those sorts of adding value at that sort of during the transaction train, if you will, is very beneficial, and that's where I say, wow, that was helpful, and I value that.
Now, I would agree in that, I particularly like when a broker calls me, like right after the contract's been signed, and just sort of introduces themselves and sort of, hey, here's where we've been, and gives me some perspective on the transaction. I think it helps make the transaction move a little bit smoother. Alon, you want to put on your broker hat for a minute, and maybe from a broker perspective?
Well, I mean, since I wear both hats, I really do see sort of both sides. I mean, from the broker's perspective, it's ABC, right? Always be closing. So, we want to make sure that that a transaction goes through, and sometimes our own sort of anxiety or may get in the way. But I've worked with brokers and attorneys who, if they're sort of committed to getting the deal done, it can work very, very well.
And I'd say maybe they're probably on the similar perspective. There are some attorneys out there that you run across that are not helpful, not aimed for that closing. So
if the attorney's perspective is I've got to be the smartest person in the room and win every single argument, that's not helpful. That's not the role I take. The role I take is I'm a counselor, which is the role I enjoy. I'm a counselor. I'm there to point out risks and give the client options to ameliorate those risks. That's the way I see my role. Not to score points. That's someone with a bigger ego than I. But maybe I have an ego just by saying that. I don't know. Yeah. So certainly both sides can get in the way. But when you're collaborative and seeing those perspectives, that's a winning combination for the client, who's the most important person at that particular time.
Absolutely. Phil, do you have something else?
Yeah, and I think that the attorney and, having come from the in-house side, had a lot of deals. I look at the attorney and the broker very similarly, in that they're there to facilitate the deal. And I mean, I remember I came out of the practice of law, and I was hired by Racetrack Petroleum. They was doing a lot of expansion at the time, and so I was running their real estate from the legal side. And there was a young, and I was pretty young back then too, but there was a young one of the real estate guys came to me, a guy some of you all may know, named Norm Ritchie, who was younger than me, and he came to me and he said, "I know you're an attorney and all, but let me tell you how it works at a company. You're here to help us get deals done, not tell us how we can't do them." And that's the real thing. You want to keep them out of trouble, but they're trying to run a business there. But I do think that the main thing, and we've worked with a lot of brokers on the bad bank book that I was running, and the main thing is to be a facilitator, be there to help on the kind of the difficult stuff. I do think there is a lot of work to be gotten from the brokerage community within the banks. Obviously, most of the banks don't think that they're the best people to list it in general. And I can tell you from our standpoint, we were always looking for the best brokers of whatever the type of product we were selling in that marketplace. So it wasn't quite the friend network to the extent that you might think. If we had something in Charlotte that was medical office, we're looking for that type of person. If we had something in Atlanta that was light industrial, we're looking for that type of person. So I thought it was always, we always tried to keep a real stable of brokers in the markets we were working with. And the people at the top of the house respect that. You've seen big changes at some of the law share banks here. And so those relationships all changed too with the brokers and the attorneys and so on. But I think they probably hired better people here, and that's an opportunity for the brokerage and the legal community as they're starting to move forward.
Yeah, I agree with Phil completely. I mean, I think that stay true, just staying true to what you do, staying true to your expertise. I don't know if you've noticed in the residential world, there's all these short sale experts or foreclosure experts. I think that as a broker, you're better off sticking to whatever your core market is, whatever you do the best that you do, and then that you'll be chosen to do that work for that reason. I think trying to sort of coin any sort of new expertise is not helpful.
Thank you. Any closing remarks from any of the panelists, and then we'll open up for questions. Questions?
$10 million loan that was booked back in at $4 million. So one has to think, and I let you go on this, one has to think, not getting $4 million, what do they actually pay for the note? And when are we going to see those kind of prices in the marketplace? I mean, so that when we're out here doing deals, if somebody's buying a note so cheap that they can simply book it back in at $4 million and still make money on it, and it's $20 million piece of property, wouldn't you guys think we're going to see those kind of prices, not on the debt buying side, but on the actual real property side, on the sales side?
Maybe 2020, 2021? No, I'm just kidding.
For the 20 million. Yeah, the 20 million is probably an old appraisal. Or, yeah.
You just got to think if somebody's looking back in a say $10 million piece of property, $4 million, that's a huge
Spread. Right.
Alon, was that a tax value? That 20 million?
The 20. Let me look. Hold on. Let me look at my note.
Are you saying that everything should be distressed?
No, what I'm saying is it's funny to hear that on the debt side, that people are buying debt so cheaply that they can still make a nice yield.
It's tough though. I mean that's a one-off, and I've seen the hoteliers, and I've sold to these folks as well. It is a hard management piece, like Alon was saying, and so they are really experts. The good ones have cash, right, and they are savvy and they understand the banking piece. But that's a real kind of exception for what we were seeing.
Okay, so just to answer your question, it was purchased in 2006 for $28 million. Okay. The tax value. Thank you. Good. I'm good. Okay, we still hear some reverb, but that's okay. 28 million in 2006. The tax value was 22 million. The 20 million was the Alon H. Price value, right? That was the value that I put on it based on the amount of rooms and the hotel and the quality of the hotel and basically its occupancy, right? It had great occupancy, which I know that you all have studied hotels in CCIM 101. You know that when a hotel at 50%, you're breaking even. At 49%, you're losing your shirt. And at 51%, you're banking. You're making money like mad. 52%, you're retiring, right? That occupancy level is very, very sensitive. Once you break past the point of covering your costs, anything after that, you really start to make money. So that was my value-based, 28, 22, 20 million. Let's call it 15 million. Let's just knock 5 million off. Let's call it 15. They still bought it at 10 and foreclosed at 4. So.
The problem in hotels are a special asset, and unfortunately I had a lot of them, and you can't run them, right? So I at the bank, and we had some smart real estate folks in our group, but we're in no position to run a hotel, and so that stuff get really wiped out on the book value, which means that we can move it out. I mean, we got killed by hotels, and I can see that being some of the cheapest stuff and some of the best deals that would move out of a portfolio. So if you had a client that was a hotelier that actually had cash, there's a real opportunity to go into the banks and buy the notes.
Yeah, so go find some good hoteliers with cash. I mean, that's what I'm saying.
But to that point, there's not going to be a time where we see a flood of these sorts of deals. It's going to be a slow sort of progression. That goes back to your 2020 sort of offhanded comment. But
yes. Gosh, I wish we could get you more positive. No, I'm just kidding.
I haven't even talked about Obamacare yet. So.
Yes, I agree. There's going to be no bloodbath in the hotel world, right? There's going to be no bloodbath anywhere, as far as from what I can see.
Jeff?
Recognizing all transactions are different. Each document is correspondingly different. Are there any new concepts or relatively new concepts that you're seeing in either leases or purchase and sale agreements that you're adding to your documents now that you may not have added in years past?
The only thing that I'm seeing a lot more of in the A-grade office space is the ability of a smaller tenant to get an SNDA. Right? It used to be that you had to have half a floor or a floor to get the SNDA. Now I'm seeing it as low as 5,000 square feet, 3,000 square feet. And I haven't seen this done many times, but I have seen brokers put their commission in an SNDA. Now, you know an SNDA is an agreement, but just to remind everyone, an agreement between the lender, the landlord, and the tenant, right? And basically what it says is that in the event that there's a foreclosure, that the lender will not extinguish the lease of the tenant, that the lease survives, right? And that SNDA document survives the foreclosure. So if you've got a commission agreement, which would normally be extinguished by a foreclosure, if your commission is in the SNDA, it will survive a foreclosure. So I haven't seen that a lot. I've only seen that a couple of times. It's somewhat sophisticated. Some lenders have a major knee-jerk reaction to it. However, I am seeing a lot more SNDAs for smaller tenants.
You know what I've seen is as some of the lenders come back and some of the folks that are buying believe that are going to get the traditional financing, is you're seeing, and you didn't used to see this back several years ago, because normally there's a due diligence period, but you're seeing them add on appraisal contingency, because they want that lending, that whatever loan they're expecting from Wells or whoever it is, and if they don't get it, that's on top of their due diligence period. And if you're not going to ride that wave with that buyer, then you might not get that price.
No, I'd agree. That's where I'm seeing a lot of deals that are being financed that is the appraisal issues causing the problem. Yes, sir.
Earlier in your presentation, you mentioned that loss share agreements are coming to an end. Could you explain that mechanism a little bit?
Well, they're not. A loss share agreement is typically 8 years long, and so during the first 5 years, the acquiring institution can receive a reimbursement from the FDIC for the difference between whatever the value was of a property. Say you got a property that's $1 million. That's the book value as of the time of closing, right? It's really worth $600,000. Okay, so the value on the book as of the day of closing is $1 million, right? They go out and get an appraisal, it's $600,000. That $400,000 is now considered a charge-off or a loss, and the acquiring institution or the bank that bought the failed bank gets 80% of that $400,000. I've told you all this before. I can see the whole room go, sort of, and so that reimbursement portion is ending after 5 years. Now that's staggered. It depends on when the bank was purchased. I mean, it's ending for the first time next year for the banks that first came in and bought failed banks.
And Alon, what are some of those banks coming due next year?
State Bank and Trust, for example. They're September of 2014. That's the sunset date on their reimbursements. Now, there's still 3 more years left on their agreement, and so they're still required to get their requirement is to maximize recovery, and they're still required to get as much as they can for the property. And during those 3 years, if they get more than what the book balance was or what the charge-off is, the last write-down, right, then they have to share that with the FDIC.
So is there much incentive for them to try to get more, or?
I'll let Phil answer that question.
I mean, that's a tough one. Hopefully, you're in the inner workings of the bank and how the team and the account officers are compensated, and are they compensated via making the book or better, the book value or better? Are they compensated by volume, or some combination of both? I think it's a tough question. I said generally you want to at the bank you want to at least get the book value, but a lot of the folks are smarter than you think at the bank, and they realize that the appraisals are rising, and that in reality the gap is that for a bank you can't go in. Let's say you've written your book down because of an 011 appraisal you got. Because I have an 013 or 14 appraisal that's higher, as a bank, it's not natural for a bank to write your book value up. So you still have that gap. So there's those opportunities in the banks that are going to be able to sell because they'll always write it down, but they won't write it up. And that's just the conservative nature of a bank. It's not necessarily the bank. The bank would like to write it up to get their capital ratios better. The regulators don't like it. So.
Yeah, one thing, we're just talking about the, sort of the relationship of attorneys and brokers, and one thing that I've been preaching to this audience for, 2-3 years now is just to basically learn the simple or not so simple, 3 or 4 accounting rules on how banks work and how that's applied to loss share. And that will give you a very good understanding that, once a bank has written something down, you can call them 150 times for 150 days, saying, well, I've got a buyer and they're ready to purchase for cash this property, right? And if it's less than the write-down, they're not going to return your phone call, right? Because they've already taken the hit on their books. So there's no incentive for them to sell the property for anything less than what that write-down is. You could call them, you can call their wife, you can call their kids, you can make 1,000 phone calls. It doesn't matter what you say to them, right? And if that value is less than what that write-down is, they're not going to do the deal. What you should be the information you should be trying to get is when is the next time they're going to do an appraisal on the property, and when is the next time there may be a potential write-down. And that's the time to start calling them and their wife and their kids and everything that you can to get hold of them. But otherwise, you're just irritating them.
Caution that on that the appraisals coming in now are higher. So what you really want to find out from these bankers is, some might tell you, some might not, is am I near your book? Am I lower? Am I at or higher than your book? So can you consider my offer? And if they're like, look, in so many words, they'll go, I can consider it, or you know what, you're not in the ballpark. And you better start bringing it up, because Alon's right. If you're under my book, I don't have a discussion. But if you're at or over, then we have a discussion. Unless it's a horrible property that you can show is worth less than the book, like a hotel.
Okay, we got time for one more question. Anything? I guess not. Thanks again to Phil, Alon, and Dan. Thank you all.
Thank you all for coming. We're adjourned, and thank you again to our panelists and our sponsors. Thanks a lot.